This is The Law Show on CL 650. Now back to the show.
They say that breaking up is hard to do. Now I know that it's true. Don't say that this is the
Hey, he was just in town a few weeks ago, and we sent a lot of our listeners off to hear Neil Sedaka sing Breaking Up is Hard to Do. Welcome back to The Law Show. Our guests from Westside Family Law, Mark Perry and Jill Chapin, in studio with us today. We've been, sticking a few pins in a few balloons. We're talking about myths that turn out to be, just that. And we're talking about spousal support and some of the myths surrounding spousal support. And here's a phrase that whenever a discussion of spousal support begins, inevitably this phrase enters the conversation within the first 5 minutes, and the phrase is taken to the cleaners. And the myth is the amount of spousal support is crippling or exorbitant or somehow akin to being taken to the cleaners. Mark, you hear that all the time.
All the time. All the time. And one of the nice things about the spousal support advisory guidelines is a documented, objective amount that is going to be paid.
Right.
And at the very minimum, we can show it to someone and say, this is the law.
Right.
And,
okay.
and that helps. That helps to understand it's not some sort of because of some marital wrong done that there's going to be a huge amount of support. And included in those printouts that we show clients is how much money they're going to have, how much the other side's going to have.
Okay.
And it's a nice way of exploding that myth to say it's close to equal. That's
okay.
what's going on here.
Okay, but there is, I'm sure, in some cases, Jill, and you encounter it frequently, there's this desire to punish. Mark was speaking to the notion of wrongs done within the marriage for whatever reasons and by whatever party.
Yep.
There is a desire to punish. And this whole night, don't take that guy to the cleaners. I don't want him left with a dime. And so even though the desire to punish is expressed in monetary terms, it can never happen, can it?
No, I mean, I think both Mark and I have had clients who've tried to invent their own grounds for spousal support and reasons why they should have more than the spousal support advisory guidelines, but there are only so many things that are going to be under consideration. Yeah.
Okay, so when you're doing this, by the way, when you're filling or feeding all of those numbers, income and assets and all the rest of it into these sophisticated programs that will give you a fairly strong idea of what the spousal support numbers will look like, what happens if one of the parties doesn't fully disclose all the numbers? So that you're just all of a sudden trying to do a formula based on, well, to some extent, a lie.
Well, first of all, I think we have some pretty good ways of figuring out when people are lying. I think a lot of people are surprised at how well family law lawyers read income tax documents and that we can see things that maybe you don't understand that we can see.
Okay.
So there are different steps and protections that clients have to make sure that disclosure is complete. And most lawyers are going to make sure disclosure is complete before a final resolution happens.
Right. And frankly, that's a reason why a negotiated case becomes a litigated case.
Yes.
Because somebody
is
reluctant to come across with the real number.
I can't show them this balance sheet or they'll know.
Right.
Yeah.
Okay.
And so, at a trial where, I'm having my adrenaline rush is I'm cross-examining a party about their income. That's what we're doing.
And a lot of people don't realize that there's something called an adverse inference that a judge is asked to draw if you refuse to disclose documents. So it's
what
not.
What does that mean?
It means that the judge can assume, well, to put it in layman's terms, the judge can assume that you're lying.
Okay. Yeah.
They're going to assume the worst of you. They're drawing an adverse inference about what you're doing there and what you're telling them. And so sometimes people think that not disclosing is a really great trial strategy. But it can have some pretty serious consequences.
Well, do they still give people a punishment for perjury these days? Is that not perjury? If you lie at trial, is that not perjury?
We don't usually pursue the perjury side.
Okay.
But under our legislation, the Family Law Act, there can be a $5,000 fine.
Oh, okay.
As well as Jill said, the judge can draw an adverse inference. So, I mean, I had a case recently where, the other side, I had them disclose their bank statements and their income, and they were somewhat self-employed, which is always kind of tricky.
Gets a little gray,
a
doesn't
little
it?
gray.
Yeah.
And then I had, prior to trial, have them disclose their spouse's bank statements because the party has a new spouse. And at trial, I argued that some of these huge cash deposits deposited to the spouse's bank account were really part of the spouse's income. And I had informed the person in advance that this is what I was going to do, and they had no explanation for some significant amounts of money that were lining up when they were receiving their pay being deposited to the other account. So effectively, the judge accepted the adverse inference I was inviting the judge to take,
Okay.
that their income was much higher than what they said.
Okay.
And that's what happened.
Interesting stuff.
So there was no fine in that case, but I think I was asking for the court to believe the person had an income of about $60,000. They were saying $40,000, not a lot of income.
Right.
But I think the judge concluded it was $55,000 or $50,000 or something like that. So
Right.
they went somewhere towards where I was going.
Getting caught in a lie, no matter what the circumstances, especially when there's oath and testimony and all sorts of stuff. Jill, it's just not the smartest thing to do ever, is it?
It's probably not a winning strategy.
No. Okay.
Jill's the master of the understatement.
No kidding. No kidding. That's very, very funny. Final myth. We got this last one to get to. Only married spouses are liable to pay spousal support.
You go for that one.
This myth, I think that this myth to some point has now been a bit dispelled, particularly because there was so much press around the Family Law Act when it came in and the changes it was making to common law relationships.
Okay.
But when you're living together, you're living in one household, you're inevitably sharing, if not financial resources, emotional resources, you're sharing your time. And that goes right back to what underlies the basis of spousal support payment that we were discussing at the start of the program that Mark was going over. You've gone into something together. Both of you have benefited. How do we quantify that benefit?
Okay, and now the Family Law Act that you've both referred to a couple of times is the most recent legislation in British Columbia, and it's just a little over 2 years old now, about 2.5 years old. How did that, and was that the first time in BC, Jill, that we acknowledged that common law relationships have equal standing in law, in particularly in family law, when it comes to these matters of payments for children or spouses?
No, actually, it predates that.
Yes.
What the Family Law Act said was that common law partners share property the same as married partners.
Okay.
But spousal support, child support, the obligations are prior to the Family Law Act. They existed prior to the Family Law Act.
Oh, interesting.
But clearly, people's awareness of the implications of being in a common law relationship was increased or enhanced by the new legislation, recognizing it's identical now to being married.
Okay.
Yeah.
Well, and as you said, Jill, this isn't exactly a fresh revelation, especially in British Columbia, but it's a formal acknowledgement of something a social trend that's been developing for decades.
Yes, a lot of the things in the Family Law Act were concepts that had been litigated. There are certain principles that were established, and they tried to incorporate them into a piece of legislation that people could apply.
Okay. And is it working? It's still a work in progress, isn't
No
it?
comment.
I mean, there's but there are still
No,
elements.
it
The
is,
judges
it
are
is.
still trying to figure this out
Absolutely.
themselves, aren't they?
Yeah,
It's early
absolutely.
days.
So for litigators, it must be kind of an exciting thing to be a part of this process in which there are areas that are still essentially untested. And you can get into that area of the tank. You can have some fun, I
Yes.
should think.
Absolutely.
Oh,
Yeah.
definitely. Interpretation of new legislation is fun for
Right.
any litigator.
Yeah.
Our guests from Westside Family Law, litigators both, can't you tell, are Mark Perry and Jill Chapin. This is The Law Show on CIL 650. When we come back, we're going to talk a little bit more about My Support Calculator and other tools available to non-lawyers before we get into this process. Also, the notion of representing yourself before any kind of legal body. We'll talk a little bit about that as well. After this quick timeout, and during which I highly recommend a visit to westsidefamilylaw.ca. See you in 2 minutes.
There's more of the show still ahead. This is The Law Show on CIL 650.